You, my lord and my ladies, and the professors on the panel. I appear on behalf of the first respondent together with Mr. Mitchell.
Thank you, Mr. and Mitchell. All right, first of all, we just wish to apologize for starting late. Unfortunately, there was a problem with some logistical arrangement. As you could see, there was going to and fro. Yes, so, but we should have started at 10:15, but due to the logistical arrangement, then we started late. And I hate to start late, so unfortunately, it's something that was beyond our control.
Yes.
With me, I'm having as Justice Modiba on my right, and on my left is Justice Yaku, and on my right is Professor Antelo Makanya, and on my left is Professor Puku. Thank you. As I indicated to you in my chambers, I'll give each of you 10 minutes time during which you'll be able to present your case without any interruption. But after the end of 10 minutes, you must expect some questions from the members of the panel. So that's number two. Number three, in terms of time, we agreed that we give Mr. Mpofu 1 hour, 15 minutes. And Mr. Waitobi 1 hour, and then Mr. Mpofu will have 15 minutes on reply.
That's good.
That arrangement still stands.
Indeed.
Okay. Is there anything that you want us to start with before we start?
Yes, my lord. Just in terms of the just logistics.
Yes.
Indeed, your lordship indicated some of the logistical problems, so the late start is not an issue from our side. The other issue that the presiding officer indicated was the issue of the bundles, the pleadings bundles.
Yes.
Our attorneys are attending, our respective attorneys are attending to securing those bundles, and we hope that they'll be here on time. It's quite a lot of photocopying.
Sure. Fair enough.
Thank you.
And then the authorities bundle as well, if possible.
Yes. Also, all right. The other side, authorities bundle is also being printed. Ours is, I beg leave to hand up.
Yes. Sure.
Yes. And ours is relatively shorter because we didn't repeat some of the authorities that they had put in their bundle. But at least for the purposes of my argument, that will it will assist as court.
I think that in the meantime we can proceed with. We'll use the electronic version of the pleadings, because unfortunately.
Yes. What we will
do could not be able to send everything.
Yes. What I will do, or at least what I think both of us will endeavor to do, when we refer, for example, to the affidavits, we'll just refer to the paragraph numbers of the affidavits to make it easier, because it's not in front of you.
Okay. Just give me a second. I just want to open my pleadings file. Okay, you may start.
Yes, there's an additional case which came loose. I forgot. Which can put it at the end of our bundle.
You can start, Mr. Mpofu.
Right. Thank you very much. Justice Zondi, the other housekeeping matter is that I will deal with, you would have noticed from our heads that we've reduced the issues somewhat. In fact, we'll reduce them even further now.
Yes.
In reality, one can say that there are 4 issues.
Okay, because previously you had reduced them from
To 5, from 7 to 5.
from 7 to 5.
Yes. But the last 2 really are one issue. That's the point I seek to make. The last 2 issues of those 5 really deal with the issue of sentence. So the 4 issues are broadly as follows. It's the issue of bias, the issue of ultra-virus. I'm just using like broad headings here. The issue of the conviction for an offense.
That be section 47 argument.
47, yes. And then the last issue is the sentence. In fact, yes, I'll deal with sentence before conviction, and I'll explain why. Yeah. But the point I wanted to make that the issue of bias, my learned friend Ms. May will address the issue of bias, and then I'll address the rest of those issues. Those issues in reality all fall under the interpretation of section 47, the rest of those issues. All right. Ms. May will come after her. Right. Okay, now I'm starting.
So your 10 minutes start now, Mr. Bofu, is 10:38.
That's
so
correct.
your 10 minutes would be over in 10:48. Okay.
Yes. Thank you.
Thanks.
Right. Well, while I have the right to speak on my own, let me just make the following opening remarks. Members of the panel, this issue, the matter really is around the gist of the matter around the interpretation of section 47(1)(e) of the Constitution. But the larger question is about the rights in section 19 of the Constitution, of the Bill of Rights specifically. And more importantly, the rights enshrined in section 19(3)(b) of the Constitution. And the sections that I'm going to deal with, whether it's the ultra-virus, the conviction, the sentence, are all around what interpretation is to be given to that section. Now, the starting point is really this, that in South Africa, in any other country, but more particularly in South Africa, we should be extremely cautious before we can ever deny the political rights of anybody. I don't have to tell this court the reasons for that. The mere reason that we have a constitution, the mere reason that we are where we are, is because people were denied political rights. People were denied the right to vote. People were denied the right to stand for political office and to hold office. And the Constitution is itself a negation of that. So our courts have said so many times in respect to section 19 and other rights in the Bill of Rights, whenever there is an opportunity not to infringe those rights, then the court must literally grab it. And we find disturbingly that the attitude of the Electoral Commission in this matter is exactly the opposite. The attitude has been, let's see where we can catch him. And when we do catch him, let's make sure that he doesn't come out alive. That cannot be the attitude of a South African institution, let alone an independent institution whose job it is to ensure that all our Section 19 rights are realized. So that's the first thing. And we cannot afford as a country to disenfranchise whether it's former President Zuma, the MK party, or whatever number of people support them. They claim that it's millions of people. They may be right. We'll know by the 29th of May. But it doesn't matter. Could be 3 people. But those people cannot be disenfranchised at a whim, as it were. So we're dealing with the rights. We actually, at face value, are dealing with Section 19.3b, but in reality, we're actually dealing with the whole Section 19, because we're dealing with the right to vote for those people who support this party and former President Zuma. Their right to vote would be infringed, because they will not have the right to choose to be represented by the people or persons that they want. We're also dealing with the Section 19 rights of the party itself, because the party, the court knows, it has been said so many times, until recently, political parties were the only vehicle through which we could all exercise our political rights. So that vehicle itself needs to be protected. Otherwise, there would have been no democracy here if there were no political parties. But we're also dealing with the rights of former President Zuma, which have been infringed. His rights in terms of Section 19.3b, which says that every citizen, those we like and those we don't like, every citizen has the right to stand for political office and, if elected, to hold political office. So there are 2 rights, 2 crucial rights embodied in 19.3b. The right to stand for political office, and the second one is qualified. It says, if elected, to hold political office. And there's a significance in those words, if elected, because the second right, one can say, is qualified to that extent. But the first one is absolute. So we are dealing with, as a country, we've been here before. We have been to a place where the powers that be felt that it was necessary to literally disenfranchise, again, we don't know the numbers, but probably millions of people, by banning their organizations, banning their leaders, and making sure that they don't participate in the political space. And as I say, at the risk of repetition, that our constitution is a bridge away from that culture to a South Africa where, if possible, everybody should be allowed to vote. We know the loose case that I handed up to the court is the case of August and another versus Electoral Commission and others, where again the IEC once again was told by the Constitutional Court that you cannot disenfranchise people, because they, like in this matter, they said, well, we have logistical problems, we cannot enfranchise, as it were, prisoners. And in any event, they have themselves to blame for where they are. Just in the same way that they are saying now, former President Zuma has himself to blame. If he wanted to stand for office, then he should not have gotten himself into a situation where he finds himself now. It's exactly the kind of mentality that was in the case of August. And in that case, it was said very emphatically that the Electoral Commission has got no right to do what it did. That whether there were logistical problems or not, it had to enfranchise those people. And the court said the following, which was very important. The right to vote by its very nature...
Just give us a paragraph number.
Oh yes, I'm sorry, ballot. Yes, it's paragraph 16.
Yes, that's it.
So the right to vote by its very nature imposes positive obligations upon the legislature and the executive. A date for the election has to be promulgated, the secrecy of the ballot secured, and the machinery established for managing this process. For this purpose, the Constitution provides for the establishment of the commission, that's the IEC, to manage elections, to ensure that they are free and fair. And I won't read the rest, but that's just the preamble. Then if you go to after that quotation, it says, this clearly imposes an affirmative obligation on the Commission to take reasonable steps to ensure that eligible voters are registered. So similarly here, the Act or the entire scheme imposes an obligation on the Commission to ensure that those who are eligible to stand for election do stand and exercise their rights. But here is the often quoted passage from this case, which really encompasses everything I'd like to say by way of introduction. Universal adult suffrage on a common voter's roll is one of the foundational values of our entire constitutional order. That's paragraph 17. Sir. The achievement of the franchise has historically been important both for the acquisition of the rights of full and effective citizenship by all South Africans, regardless of race, and for the accomplishment of an all-embracing nationhood. The universality of the franchise is important not only for nationhood and democracy. The vote of each and every citizen is a badge of dignity and personhood. Quite literally, it says that everybody counts. In a country of great disparities of wealth and power, it declares that whoever we are, whether rich or poor, exalted or disgraced, we all belong to the same democratic South African nation. That our destinies are intertwined in a single interactive polity. Rights may not be limited without justification, and legislation dealing with the franchise must be interpreted in favor of enfranchisement rather than disenfranchisement. Contained there is...
So I just want to warn you.
Yes, I am aware the 10 minutes is up.
Now.
Thank you,
we may start expecting questions from the
As God pleases, my Lord. I'm indebted to the court for the reminder.
Sure.
Now, the reminder came in time because, as I say, that quotation encapsulates everything I want to say in terms of setting the canvas about this case. Whether you are rich or poor, exalted by everyone or the media, or disgraced by them, we all belong to the same democratic South African nation. And we must favor enfranchisement rather than disenfranchisement, and banishment and separating people away. And there's no better case, again, to demonstrate that than the case of August, because they were dealing with prisoners convicted and sentenced in the conventional way, just as what Mr. Zuma is being accused of. But the court said, no, despite whatever those people might have done, they might have been rapists or whatever, but you can take away their freedom of movement, but you cannot take away their right in terms of Section 19. So, against that background, I will deal very briefly with the issue of alpha virus. This is a very important issue that goes into interpretation, of course, as this case is really all about, but it also goes to some of the foundational values of our democracy. The supremacy of the Constitution and the separation of powers. It also goes to the multi-party democracy, all the values that are enshrined in Section 1 of the Constitution, as well as the right to human dignity, as was said in paragraph 17 of August, that the right to vote is a badge of dignity, particularly for those who were disenfranchised by apartheid. Now, what we're saying under this section, esteemed members of the panel, is this. Until now, and this case is important for this, until now, the question as to whether who must implement Section 47 has not been asked and has certainly not been answered. There was an assumption that the Commission is the agency or organ that must administer that. But that's how the law develops. We have assumptions until such time that the issue has been raised. And the issue we're raising is the following. There is, in terms of the rule of law, because we know ultra vires is the old Latin term for what we now call the principle of legality or rationality and so on. Sometimes it's called authority, sometimes it's called jurisdiction. It doesn't matter what the term is. But the concept is the following. And that concept was captured in the leading cases of Fetcho, pharmaceutical, and so on. That public officials...
Sorry, Mr. Pope, before you proceed, I think that we need to contextualize Section 47.
Yes.
It's in the following context.
Right.
Mr. Zuma, the former president of the Republic of South Africa, is among the list of candidates that was submitted by the MK party on the 8th of March 2024. So far, so good. And then there was an objection submitted to the IEC on the 26th, 27th of March 2024 by two people. Well, it's the second respondent and the third respondent. The third respondent has since distanced himself from the objection. So we are now remaining with the objection of Dr. Matsapula.
Correct.
And it is on the basis of that objection that the IEC made a decision. That's where we are now. Okay. Now, the question is whether or not the IEC, in relying on Section 47, was correct. So it's about the interpretation of Section 47, whether it excludes or it includes Mr. Zuma. That's the whole case. That's the whole thing, issue of this case.
No.
So it's about the interpretation of Section 47.
Yes, no, it is. Well, that part is correct. Man.
Yes.
It is about the interpretation of Section 47.
Yes.
But the point I was making, my lord, is that it's not about the what I call the merits in our heads, which is whether Mr. Zuma is excluded or included only. It's about the preliminary point that I'm raising.
Yes.
Whether, in the first place, the administration, for lack of a better word, of Section 47 lies in the hands of the IEC.
Okay.
That's
so
the issue.
We at this stage, we are at ultra vires point,
right.
whether or not the IEC had authority to do what it did. That's whole thing about. That's whole debate about jurisdiction, ultra vires authority. Yes. So that's where we are now in relation to Section 47.
Absolutely.
Okay.
Yes, and that's why I said.
Now, your argument is the following: IEC does not have authority. That authority belongs to the National Assembly or Parliament.
Yes.
Is it well?
Yes.
Okay.
And
Sure.
Thank you, my lord. So, my lord, and we say this for the following reasons. If you look at where Section 47 is located
Yes.
in the constitutional scheme, it's in Chapter 4. Chapter 4 of the Constitution is headed Parliament. The Parliament meaning the National Assembly and the NCOP. That's what we call Parliament in South Africa. And then the heading to Section 47 says membership. And so it deals with the membership of the National Assembly. And as if that's not enough, the section itself makes it clear what it deals with. It says, it starts by, crucially, starts by reminding us of section 19. It says, every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly. Very important. You know, how a statute is framed, a statute is basically a way of communicating. It's a National Assembly writing us a letter as a nation. So they start by reminding us of section 19, that every citizen, including Mr. Zuma, who is qualified to vote for the National Assembly is eligible to be a member of the Assembly. And then it says, except. Now that formulation already tells you something. We try to include everyone, and then but there are exceptions. So already that is the ethos of this, that we must not start by excluding, as the IEC seeks to do. We start by including, and then we apply the exceptions. And then this is the crucial part. It says, except, we go to E. Anyone who, after this section took effect, there's no problem with that, is convicted of an offense, that's the first thing. And, that word and is important, not or. And sentenced to more than 12 months imprisonment without the option of a fine, as the Lordship said, so far so good. Either in the Republic or outside of the Republic and so on. And then but, again, so there's another exception within the exception. But, it says, or is what we call a proviso now. But no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time of the appeal has expired. A disqualification under this paragraph ends 5 years after the sentence is completed. Yeah. So we'll come to the bits and pieces of that section. The point we're making now is simply this. The IEC does not have, or must show this court, in terms of the Federal case, the IEC must tell this court where it gets the authority to implement Section 47. And the answer is nowhere. And the quotation I put there from Baxter is very important. You don't say when you apply the rule of law, well, we can do everything that we are not prohibited from doing. No, it doesn't work like that. It says we can only do those things that were authorized by law to do. So if you are doing something as a public official, if someone wakes you up and says, where did you get the authority for this? You must be able to wake up and say, section this and section that and section that. And then we leave you alone. But if you are unable to point to any authority that empowers you to do something, then it's ipso facto ultra vires. Now, so the only authority, the only power of the IEC, my Lord, is found in section 190 of the Constitution. So it cannot do anything outside of that. It's a creature of statute. You can't just wake up and do what you want. So, and 190 says the Electoral Commission must manage elections, I'll use shorthand to save time. Manage elections, we all know that. Ensure that those elections are free and fair, we all know that. Declare the results of those elections, we all know that. And that's it. And then it says at 92, which is the catch-all phrase, which maybe they will rely on. The Electoral Commission has the additional powers and functions prescribed by national legislation. So in other words, the IEC only has the powers prescribed in section 190, they will manage elections and so on and so on, or they would get those powers from legislation. Now let's go to the applicable legislation.
Mr.
I'm sorry.
I'm sorry, but before we go to the applicable legislation, when we're interpreting or giving content to the powers of the IEC in the context of elections for the National Assembly, do we not also have to look for interpretation purposes at section 47.2,
Yes, we will come to that.
You're getting there.
Yes, we definitely will come to that. But you see, it's said in when the Constitution, my lady, disenfranchises somebody, it will not do it by silence. I can assure you. That's what he said in August.
But
It will.
Sorry.
I'm sorry.
I just wanted to finish because my question had two parts, and
Right.
it's fair to put the whole thing because you probably do
Sorry,
the whole
ma'am.
thing.
Yes, ma'am.
And it relates almost directly to disenfranchisement, because if you say, if this court, for example, were to find that the power lies not with the IEC but with the National Assembly to exclude a person in terms of 47(1)(e), is that not then a sort of disenfranchisement by stealth? Because then the person, as a voter, I think, oh, my person is a candidate, that means my person qualifies because the decision has been made to allow my person to be a candidate, and then I vote for that person. And then the National Assembly says, no, in terms of section 47(1)(e), you are disqualified. So then I voted for this person, but my vote doesn't count because now after the fact, the National Assembly is disqualifying them.
Well, that is exactly what happens every day. That's what should happen. Let me explain.